Hello, my name's Simon Wadlow and I'm one of the directors of Total Legal Solutions. We're here today to deliver you a training seminar based around costs from our technical manager, Alex Bagnall. I am sure that you will find this of great use to you and your team, and if you do, it would be a pleasure to work with you in the future on your cases. Should you require any bespoke training around any particular topic, then we'd be happy to deliver this for you. Many thanks.
Hi, my name's Alex Bagnall. I'm a costs lawyer and the technical manager at Total Legal Solutions. I've got over a decade of experience in dealing with commercial disputes. Within this video, we're going to be looking at the three most important cost issues which commercial litigators need to be aware of in order to provide the best possible service to their clients. The way in which litigation is funded is important for all lawyers, but in particular for commercial litigators. Where some types of consumer-focused law may always go towards a CFA, commercial litigators often have the luxury of having many different methods of funding available to them. And understanding the different ways in which litigation can be funded can allow you to attract a broader spectrum of clients. It can also help you to retain current clients because, of course, client circumstances quite frequently change. Importantly, it ensures that you get paid for the work that you're doing and that you get paid at a reasonable level. And finally, in litigation work, it allows you to ensure that the level of costs which are recovered into parties is commensurate with the work that you've done in order to ensure that the indemnity which your client gets is as close as possible to the level of costs which they've had to pay in order to deal with the work. Traditionally, commercial litigators would always look to fund litigation on a private paying basis. But of course there are many different methods in which litigation can actually be funded. Some firms are happy to take litigation on a CFA. Other firms might look towards discounted conditional fee agreements. Firms which have access to large amounts of data can possibly look to offer fixed fee funding. In high value litigation, third-party funding may be appropriate. Many clients will have legal expense insurance that might be able to fund litigation. The inevitable question which follows from the wide array of different funding options which are available is which of these is best. And the answer to that is that there is no one-size-fits-all approach. The type of factors which you need to have regard to include things such as the liquidity of your client. If your client doesn't have particularly deep pockets, then there's very little point signing them up to a funding arrangement which requires them to pay hundreds of thousands of pounds in fees. You'll inevitably end up with a situation where you'll have a lot of bad debt, it will lead to a fractious relationship with your client, and you won't get paid for the work which is being done. Prospects of success is important. If a case has very limited prospects of success, then operating on a full no-win, no-fee agreement wouldn't be sensible because the chances of getting paid at the end of that case would be slim. The value of the claim is important. If you're going to be charging your client the shortfall between the level of costs which are incurred and the level of costs which are recovered, if the litigation is only in relation to a modest sum of money, then your client might not be able to afford to meet that shortfall out of their own pocket. Similarly, if it's a low-value claim, then acting on a contingency fee or damages-based agreement wouldn't be particularly appropriate because the level of fee which could be charged wouldn't cover the work which is to be done. The prospects of recovery can also be important. If you're acting on a funding arrangement which limits the amount which you can charge to the amount which is recovered from your opponent, if you have a straw man opponent or an opponent which is not in a particularly good financial position, then entering into that type of funding arrangement could result in you going unpaid. The likely conduct period can be important. Again, if you're acting on a CFA basis, how long will it be before you can actually charge for the work which has been done? Who's going to pay for disbursements? In a case where the disbursements are limited to a few £1,000s, most clients can probably afford to do so themselves. But if you need to spend hundreds of thousands or potentially millions of pounds on disbursements, then it may be the case that you need to look for some alternative method of paying for those as you go. Whichever method of funding you choose, it's incredibly important to ensure that it's committed to writing and it is clear. The Legal Ombudsman deals with an awful lot of complaints from clients about the level of costs which their solicitors have incurred. Frequently, those complaints relate to solicitors charging for things which the client didn't think that they were liable to pay for, or solicitors charging on a basis which was inconsistent with what the clients thought had been agreed. And the legal ombudsman actually give guidance in one of their information leaflets that good recording of what has been agreed often resolves disputes before they become a major disagreement. There's also a very clear line of authority that if there is a disagreement between a client and a solicitor about what was agreed, and there is no contemporaneous evidence which supports one view or the other, then the word of the client is to be preferred over the word of the solicitor. So from the point of view of ensuring that you can charge for the work that you've done on the basis that you think you are able to charge, it's essential to commit these agreements to writing. Whenever you meet with a new client, it's a very good idea to explore whether there are some alternative methods of funding the litigation. In the McDaniel case, a firm of solicitors accepted instructions to act on a privately paying basis without undertaking any investigations into whether the client could have funded the litigation in some other way. It subsequently transpired that the client did have access to an alternative method of funding, which meant that she wouldn't have had to pay any of the costs out of her own pocket. When the client subsequently challenged McDaniel's bill of costs on this basis, the cost judge concluded that their failure to investigate whether there were any other ways of funding the litigation meant it was appropriate that they should not be entitled to charge for any of the work which they've done. Providing your client with a meaningful and accurate estimate of costs is also very important. Clients will often rely on estimates which you provide as a basis for entering into litigation. If a client believes that litigation is only going to cost a few tens of thousands of pounds, then they may be more inclined to go for it than if the litigation was going to cost several £100,000. In the Reynolds case, an inadequate estimate of costs was provided to a client, and the cost judge subsequently concluded that that estimate of costs was a key factor in the client deciding to proceed with the litigation, and if the estimate had been more accurate at the outset, they may not have done so. And for this reason, the solicitor's costs were significantly reduced at the assessment. Inadequate estimates can also be a special circumstance which allows a client to challenge a solicitor's bill of costs out of time, and that was what happened in the Eurasian Natural Resources case. Where an estimate of costs proved to be woefully inadequate, the court concluded that the inadequacy of the estimate was a special circumstance which allowed the client to challenge the invoice more than 12 months after it was raised. Another important factor to be aware of is hourly rates. It can often be the case that solicitors' retainers include set hourly rates with no provision for them to be increased as the case continues. It's important to ensure, particularly in litigation which is likely to run for several years, that there is contractual scope within the retainer to increase the hourly rates. If that scope isn't there, then any subsequent increases to the rates may not be contractually enforceable. When you come to structure your funding arrangement, it's important to set out exactly what is covered by that retainer. Are you acting only in the claim, or are you also acting in relation to the counterclaim? Do you wish to cover an appeal? There are some benefits in the original retainer document covering an appeal, but of course the downside to that is that you could find that you are contractually obliged to pursue appeal after appeal, even if the prospects of doing so are absolutely hopeless. If your costs are going to be of an unusual nature or amount, then it's essential that you obtain informed consent from your client to do so. In the McDougall case, the hourly rates which were charged in the retainer were significantly higher than what was the going rate, and the reason for this was because the solicitors had agreed to defer payment. No information was given to the client about the likelihood of these costs being recovered, and subsequently the solicitors agreed to accept on an inter-parties basis significantly lower hourly rates than what the client was contractually bound to pay. The court concluded that charging such high rates and not giving the client enough information to make an informed decision about whether they should agree to pay those rates meant that the costs were unusual. In Breyer and Prospect Law, a firm of solicitors charged on the basis of 10-minute units rather than 6-minute units. Again, the court concluded that this practice was unusual. The effect of a finding that costs are unusual in nature or amount means that at a detailed assessment on a solicitor-client basis, those costs will be presumed to be unreasonably incurred and/or unreasonable in amount. And so the burden in the detailed assessment hearing will transfer to the solicitor to show that those costs should be payable, rather than to the client to show that the costs should not. Closely allied with getting the funding right is getting the billing right at the end of the case. When we talk about bills, we're talking about invoices, the instrument which you send to your client in order to ensure that you can get paid for the work which is done. In order for a bill to be a valid bill, there has to be an entitlement to raise it. The bill has to include a sufficient narrative, it's got to be signed, and it's got to be delivered to the client. The court will classify bills as falling within one of two distinct types. The first is a statute bill, and the second is an on-account bill. Only a statute bill can be sued on. If you deliver a bill to your client which does not meet the requirements of the Solicitors Act, then you will not be entitled to sue your client for payment of those fees. Any bill which does not meet the requirements of a statute bill will be considered to be a request for a payment on account of costs. You can only raise a statute bill at the conclusion of the retainer, so that's where all of the work which you are contractually obliged to do has been completed. You can raise a statute bill where the retainer is terminated by the client or where you have lawfully terminated the retainer. But it's really important to bear in mind that if you don't lawfully terminate the retainer, then you are not entitled to be paid for any of the work which has been done. Or you can raise a statute bill where there is an express or implied agreement to do so. An express agreement will normally be found within the retainer document itself, but it could of course be entered into subsequent to that. An implied agreement to raise a statute bill will normally arise where a solicitor has raised a series of bills which don't strictly comply with the Solicitors Act, but which the client has nevertheless treated as being a statute bill. It can be difficult to establish that there is an implied agreement to raise a statute bill, and so if you do intend to raise statute bills, it's very important to ensure that there is a contractual agreement to do so. A bill of costs needs to include a narrative, and that narrative has to be sufficient to allow the client to decide whether the charges which are being raised for the work done are reasonable. The narrative doesn't need to be contained within the bill itself, it can be included in appended documents, and a fairly standard practice is to include the time recording ledger with the bill of costs. That will set out all of the work which was done, how many letters were sent, who the letters were sent to, how many telephone calls were made, how long they lasted, what work was done on documents, and so on and so forth. And that should be enough to allow the client the opportunity to decide whether those fees are reasonable. It is, however, a good idea to include some kind of qualitative narrative within the bill itself, which sets out in brief terms, a paragraph or so, the nature of the work done. The narrative should also specify the date which is covered by the bill itself. The court can have regard to the information which is in the client's possession and the sophistication of the client when deciding whether the narrative provided in the bill is sufficient, but it's a good idea not to have to rely on this. So by providing a detailed billing guide of the work which was done, you can often avoid any arguments about whether the narrative is sufficient. The next requirement is for the bill of costs to be signed. The bill doesn't necessarily need to be signed by a solicitor, it can be signed by somebody who is authorised by the solicitor to sign a bill. And it's not necessarily the bill itself which needs to be signed. The covering letter under cover of which the bill is sent can be signed. Electronic signatures are perfectly acceptable, provided that they meet the requirements of Section 7.2 of the Electronic Communications Act 2000, but those requirements aren't particularly onerous, and I would guess that the vast majority of law firms' electronic signatures will meet the requirements. Finally, the bill of costs has to be delivered. For a bill to be delivered, it's got to be sent to the party who is responsible for paying the bill. It can be sent by post, or it can be delivered personally to them. It can be sent to their last known place of business or their last known address. Bills can only be sent electronically if the client has agreed in advance for this method to be used. If there's no advance agreement, then sending a bill electronically to a client arguably means that it hasn't been delivered. Meeting the requirements for a bill to be a valid statute bill are very important when it comes to looking at the time limits which apply in Solicitors Act detailed assessment proceedings. A solicitor cannot sue on any bill which is not a valid statute bill. Where a valid statute bill has been delivered, a solicitor cannot sue on it within the first month. Within that first month, a client has an unfettered absolute right to challenge the bill of costs. Once 1 month has passed, the solicitor can then sue the client for payment of the bill. The client can attempt to challenge the bill of costs. They will generally be given permission to do so, but the court has the power to impose conditions on that assessment up until the point that 12 months has elapsed since the bill was delivered. After 12 months, the client can only challenge the bill if there are special circumstances. Special circumstances doesn't mean exceptional circumstances, but the bar is still set very high for a client to be able to challenge a bill after this period of time. And once 12 months have passed after the bill has been paid, the client has no right whatsoever to challenge the bill under the Solicitors Act. But of course, these time limits only apply where the bill is a valid statute bill which has been validly delivered. Understanding cost management is important for all litigators. Where your client is paying the costs out of their own pocket, it's important that they are aware of how much can be recovered for the work which they're instructing you to do and how much is likely to go unrecovered. Where a cost management order is made, it's a good opportunity to discuss with your client the level of work which is going to be done, the level of costs which are going to be incurred, and the level of costs which are likely to be recovered under the terms of the cost management order. This gives your client an opportunity to instruct you to cut your cloth according to the cost management order if they wish to do so. So possibly use lower grade of fee earners, possibly don't take certain steps, perhaps provide less detailed witness statements. Or alternatively, the client can proceed with the litigation in the knowledge that the level of costs which are going to be paid is likely to be higher than the costs which are going to be recovered. But it gives the client an opportunity to make an informed choice about how the litigation should be pursued and to undertake a cost-benefit analysis. If you're acting under a funding arrangement which restricts the level of costs which you're going to be paid to the level of costs which are recovered from your opponent, a cost management order gives you the information you need in order to work out what is likely to be paid, and this can allow you to plan the litigation to ensure that it is done profitably. Cost management orders automatically apply in all multi-track Part 7 litigation, except where the value of the claim is over £10 million, where the claim is made on behalf of a child, where proceedings are subject to fixed or scale costs, litigants in person don't need to put a cost budget in, and the court has the power to order otherwise. The practice direction gives a list of certain Part 8 and other proceedings where cost management orders are appropriate. They include unfair prejudice petitions, directors' disqualification proceedings, Talata applications, claims brought under the Inheritance Act, and any other Part 8 claim which involves a substantial dispute of fact or is likely to require oral evidence or is likely to need extensive disclosure. Under Rule 313.3, the court has a discretion to impose cost management orders in any case, even those where the rules do not automatically require a cost budget to be prepared. And where the parties agree that a cost management order should be imposed, even in cases which aren't covered by the rules, then the court will, except in exceptional circumstances, make such an order. It's important to be able to identify whether you need a cost budget, and if so, by when, because the sanctions for failing to comply with the rules requiring provision of budgets are so severe. If the value of the claim is pleaded at less than £50,000, then you need to put your budget in with the directions questionnaire. In all of the cases, the budget goes in not less than 21 days before the first CMC. And it's important to bear in mind that 21 days means 21 clear days. There are a number of authorities where parties have understood 21 days to mean 21 calendar days, with the consequence that the budget has ended up being a day late. If you don't file a budget, as required by the rules, then you are treated as having filed a budget which contains court fees only. This poses difficulties on detailed assessment, because as we'll see in a few moments, the court is restricted in what it can allow on a detailed assessment to the level of costs which were contained in the last approved or agreed budget. If your budget is late, you can apply for relief from sanction, but the authorities dealing with relief from sanction in these circumstances really just show how inconsistently courts deal with these types of applications. A lesser known way of getting some kind of relief is Rule 3623. This rule provides that if your budget is restricted to court fees only, but you subsequently beat your own Part 36 offer, then you'll be entitled to recover 50% of the costs which you would have otherwise been awarded, but for the sanction being imposed. But of course, neither of these routes is particularly satisfactory. Applications for relief from sanctions are always a gamble, and being able to recover just 50% of your costs, particularly if your client is having to pay those costs out of their own pocket, is never going to be a particularly satisfactory result. At the CCMC, many parties will take some comfort from Practice Direction 3E Article 12, which provides that the court is only concerned with whether the level of costs which are claimed within a budget are within a range of what is reasonable and proportionate. The practice direction is very clear that the court shouldn't be undertaking a detailed assessment in advance. However, Articles 5 and 6 of the same practice direction suggest that the court can look at budgets in more granular detail than simply the headline figures. Practice Direction 5 says that the court should have regard to the 8 pillars of wisdom, which deal with reasonableness, and the Jackson 5 criteria, which deal with proportionality when deciding whether costs are reasonable and proportionate. And Practice Direction 6 suggests that the court can ask parties to justify both the grade of fear in doing the work and the amount of time which is going to be spent in each phase. So it's important that where you attend CCMCs or where you brief counsel to attend CCMCs, that your advocate is ready to deal with arguments in more detail about how the costs have been arrived at. One frequent criticism of cost management is that the CCMC takes place at such an early stage that it can be very difficult to predict how a case is going to pan out. This is particularly acute in commercial disputes, where there can be an awful lot of threads which need to come together before the trial can take place. This was an issue which faced Mr. Justice Flo in Wright and Rowland. In Wright, the defendant suggested that it required representation at trial in the form of 1 silk and 2 juniors. The claimant's position was that this was a relatively straightforward factual dispute which was going to turn on whose evidence the court preferred following cross-examination, and as a result, the claimant suggested that 1 silk and 1 junior was appropriate. Mr. Justice Flo suggested that he was being invited to make one of 3 decisions. The first was to allow the costs of 1 silk and 2 juniors, but if the claimant was correct that this was going to be a straightforward factual dispute, then the defendant might go over remunerated at the trial. The second was to allow the costs of 1 silk and 1 junior, but if the defendant was correct that this was going to be quite a heavyweight dispute, then the defendant could be underrepresented at the trial. Or the third was to apply the wisdom of Solomon and allow the costs of 1.5 juniors, but he concluded that that wasn't going to be to anybody's benefit. So instead he budgeted the case up to the PTR phase, and he said that the cost judge could decide retrospectively what was reasonable and proportionate at the trial preparation and the trial phase based on what had actually happened rather than what was being predicted to happen at such an early stage. And this approach is entirely consistent with Rule 313.4, which suggests that the court can parcel up the litigation and budget certain aspects of it and then revise budgets at a later stage in heavyweight litigation. At the CCMC, the court doesn't have any power to interfere with costs which have already been incurred. The court can't approve those costs, it can't disapprove those costs, it can't reduce the costs, it can't interfere with hourly rates. All the court can do is record comments on the costs which have already been incurred. In Cliff Richard's dispute with the BBC, by the time the CCMC came around, he'd already spent over £1 million in costs. The BBC asked the Chief Master to make a recording that those costs were unreasonable and disproportionate based on the information which was available at the time. The Chief Master declined to do so, despite agreeing that the costs were objectively and on their face very high. And the reason for this was because he identified that the information which the cost management judge has is very minimal. They have effectively a spreadsheet which sets out the amount of time which has been spent and the hourly rate which has been applied to that work, and they have details of the disbursements which have been incurred. But that's it. At a detailed assessment, the cost judge is going to have access to every sheet of paper which was generated in the case, and that means that the cost judge is in a far better position than the cost management judge to decide whether the incurred costs are reasonable and proportionate. The Chief Master also suggested that there was a risk that the cost judge would place disproportionate weight on any comments which are recorded based on potentially incomplete information. Parties are under an obligation to ensure that the work which is being done is consistent with the assumptions which applied when the cost budget was approved. Rule 315A1 imposes an obligation on parties to make an application to revise a cost budget where there has been a significant development. The interesting thing about this rule is that it imposes an obligation to revise budgets upwards as well as downwards. This can be used strategically to reduce the level of costs which one's opponent would be able to recover at the end of the case if the litigation takes on a different complexion to how it appeared at the date of the CCMC. The obvious question which arises from that previous slide is, what is a significant development? There's quite a few more authorities out there which deal with what are not significant developments rather than what are significant developments. And this reflects a view amongst certain quarters of the judiciary that once a budget is set, it should be very difficult to depart from it. So for example, if the original budget is set based on an error and that error is subsequently identified, the identification of the error is not going to be a significant development which allows the court to revise the budget. In Gregg and Lachlan, a budget was set based on council's fees, which council ultimately was unable to work within. The court concluded that instructing a barrister who couldn't work within the confines of a budget was not a significant development. In Churchill and Boot, the value of the claim was increased significantly and an application was made to revise the budget on this basis. The court concluded that the increase in the value of the claim alone was not a significant development, and on the facts of this case declined to revise the budget. Indeed, the new rules require the parties to certify that the costs which are being claimed as a result of the significant development were not claimed within the original budget. In Sharp and Blank, the Chief Master concluded that a development can only be a significant development if it leads to a significantly proportionate increase in the costs which are to be incurred in one particular phase. However, in Al-Najjar, the High Court was at pains to explain that the bar for a significant development should not be set too high. It's important for access to justice purposes that parties should be permitted to revise their budget if there is a genuine significant development in the claim. The classic example of what is a significant development arose in the JSC and Viktorovich matter. In that case, the length of trial was increased. The court concluded that that was a significant development. And in Sharp and Blank, the Chief Master concluded that where thousands of pages of additional documents had arisen out of a third-party disclosure application, that was a significant development, as was the existence of expert evidence which had not been predicted at the CCMC, and similarly the wholesale retimetabling of the claim was a significant development. It's important to keep one eye on the level of costs which are being incurred as the litigation progresses, because Rule 318B is very clear that at the end of the case, on a standard basis detailed assessment, the cost judge will not depart from the last approved or agreed budget unless there is a good reason to do so. In Sony and SSH, the High Court observed that the requirement to stick to the budget applied on a phase-by-phase basis. So you can't overspend in one phase and then borrow from an underspend in another phase in order to try and balance things out. It's therefore important to undertake regular checks of the costs which are being incurred on a phase-by-phase basis to ensure that you're not going over budget, and if you are about to go over budget, to attempt to identify if there are any significant developments which could allow you to revise the budget. In Harrison and Coventry, the Court of Appeal were very clear that the requirement to find a good reason to depart from the budget represents a deliberately designed significant fetter on the court's discretion as to costs. The Court of Appeal made it clear that cost judges should not adopt a lax or overindulgent approach to finding a good reason, because if they do so, that would undermine the purpose of cost budgeting. An important recent development in cost management is the Lejon-Von decision. There has been an ongoing debate for many years at High Court level about what the effect of an indemnity basis costs order was where a cost management order had been made. Mr. Justice Coulson held twice when he was a High Court judge that the cost management order would nevertheless apply even where there were costs being assessed on the indemnity basis. However, Lord Justice Coulson, as he now is, concluded in Lejon-Von that the cost management order does not apply on the indemnity basis. My final tip is to identify ways in which costs can be recovered against parties who are ultimately impecunious. Ordinarily, when one thinks of third-party costs orders, one would be looking to recover against commercial litigation funders, potentially against company directors, and in certain limited circumstances, even against firms of solicitors. The court's jurisdiction to make a non-party costs order is found at section 51 of the Senior Courts Act. Now, this statutory provision is drafted in very wide terms, and in the aid and shipping matter, the House of Lords concluded that it gives the court a power to make an order against anybody, regardless of whether or not they are a party to the litigation. The procedural framework for making non-party costs orders is contained in Part 46 of the CPR. Non-party costs orders are exceptional. Exceptional means that they are not run-of-the-mill. When the court's considering whether to make a non-party costs order, it's principally concerned with identifying whether the non-party was actually the real party to proceedings. And there's generally a three-stage test for this. Did the non-party fund the litigation? Does the non-party control the litigation? And did the non-party stand to benefit from the litigation? There's also a causation test which has to be applied to the non-party. Causation can be that the non-party caused costs to be incurred, but it can also be that the non-party did something to prevent the successful party from being able to enforce its entitlement to costs. Procedurally, there should be an early notification of the intention to make an application for a non-party costs order. However, if early notification isn't given, that in and of itself is not enough to defeat the application. It's essential for the non-party to be joined to the proceedings as a party in order to enable them to take part in the application. The application should be heard by the trial judge except in exceptional circumstances. And when the application notice is being drafted, on its face it should be made clear that the trial judge should hear the application. It's not enough, as was the case in the Gochner matter, for the application notice to provide that it should be heard by the trial judge if they are available, or some other judge if not. It is essential, unless there are exceptional circumstances, for the trial judge to deal with the application. When the court is considering the question of funding, it has to draw a distinction between pure funders and third-party funders. Pure funders have no personal interest in the litigation, they don't control the litigation, they're not funding the litigation as a business, and they will not benefit from the outcome. By contrast, third-party funders are to be seen as being the real party to the litigation. They're not facilitating access to justice for the party who is funded, but they are funding the litigation for their own benefit. Generally speaking, the court should decline to make a non-party costs order against a pure funder, but should make a non-party costs order against a third-party funder. In the litigation between Neil Hamilton and Mohammed Al-Fayed, the Court of Appeal concluded that people who had donated to a fighting fund for Mr. Hamilton, what we'd now call crowdfunding, were not liable to pay Mr. Al-Fayed's costs following the litigation. In 2005, the Court of Appeal dealt with the matter of Arkin and Borchard lines, and the Court of Appeal's conclusion was that in that case, the liability of third-party litigation funders should be limited to the amount of money which they'd put into the case. Arkin was effectively treated as a set-in-stone rule for 15 years, even to the extent that Sir Rupert Jackson, in his final report, recommended that the Arkin decision should be reversed by rule changes. However, in 2020, the Court of Appeal dealt with the matter of Chapelgate and money. In Chapelgate, the Court of Appeal suggested that everybody had actually misunderstood the effect of Arkin for the past decade and a half. Rather than establishing a concrete rule, the effect of Arkin was simply to do justice on the particular circumstances of that case. And whilst the Arkin decision is a relevant matter that the court has to have regard to when deciding how much a litigation funder should have to pay, it is simply one of many different circumstances which the court can have regard to. So it is, in appropriate circumstances, possible to obtain a greater indemnity from a third-party funder than the amount of money which they have contributed towards the litigation. In cases involving corporate litigants who end up being either insolvent or otherwise unable to pay the costs which have been directed to be paid, it can be tempting to attempt to go after the directors or shareholders of that company in order to meet the costs order. However, such applications can be very difficult to succeed on. In Housemaker Services, the High Court made it clear that the court has to recognise that there is a separate liability for companies and directors, and that there has to be something more than in other non-party costs order applications for a director to be made liable for the costs which the company is otherwise liable to pay. The fact that a shareholder might benefit from the litigation does not in and of itself mean that the shareholder was the real party to the litigation. So where proceedings are brought in good faith, where they're conducted properly, and where they are in reality for the benefit of the company, then the company is the real party and it's not appropriate to make a costs order against a director. The authorities contain plenty of examples of parties trying to enforce costs orders against solicitors. Frequently, it's said that solicitors are actually funding the litigation. In Tolstoy, Miloslavsky and Aldington, for example, Count Tolstoy was an undischarged bankrupt who owed Lord Aldington a very substantial sum of money from previous litigation. Count Tolstoy convinced a firm of solicitors to act for him pro bono in order to attempt to set aside that judgment. The application was unsuccessful, and Lord Aldington, who was unable to enforce the costs order which was then made in his favour because of the fact that Count Tolstoy was bankrupt, argued that the firm of solicitors had funded the litigation by agreeing to act pro bono. The Court of Appeal disagreed. Acting pro bono is not a good reason to make a costs order against a firm of solicitors. In fact, there are many reasons why solicitors would be encouraged to act pro bono, and disincentivising them from doing so would be against public policy. Similarly, where solicitors act on a CFA basis, that in and of itself is not sufficient for a costs order to be made against the firm of solicitors. However, where solicitors are the real party to the proceedings, then they may be exposed to a third-party costs order. In Myatt, for example, a CFA was held to be unenforceable, with the result that the client wasn't liable to pay anything to the solicitors, and the solicitors couldn't recover an indemnity for costs from the defendant. The appeal to the Court of Appeal would have served no benefit whatsoever to the client. The appeal was ultimately unsuccessful, then the defendant obtained a non-party costs order against the solicitors on the basis that they stood to benefit from the litigation rather than the client, and therefore they were the real party. It is possible to obtain a wasted costs order against a firm of solicitors, or indeed against any other legal representative. The gateway to a wasted costs order is that there has to have been improper, unreasonable or negligent conduct by a legal representative. The legal representative, however, need not be a qualified or authorised lawyer. That conduct has to have led to costs being incurred by another party, and it has to be just in all of the circumstances to require the legal representative to compensate the other party in whole or in part for those costs. Improper conduct is the type of conduct which would justify disbarment, striking off, suspension from practice or some other serious professional penalty, although it's not restricted to that type of conduct. It can include any significant breach of a substantial duty imposed by a relevant code of professional conduct, or it can be conduct which would be regarded as improper according to the consensus of professional opinion, including judicial opinion, even if it does not violate the letter of a code of professional conduct. Unreasonable conduct is generally vexatious. It's conduct which is designed to harass rather than progress the case. Conduct cannot be described as unreasonable simply because it leads to an unsuccessful result, or because other legal representatives, particularly more cautious legal representatives, would have acted differently. The acid test is whether the conduct permits a reasonable explanation. Negligent conduct is to be understood in a non-technical sense, and it's the standard which is reasonably expected of ordinary members of the profession. The nature of the litigation, the nature of the legal representatives who are engaged in the litigation is not important. The standard is the typical, reasonably well-informed high street solicitor. Common difficulties which can be encountered when making an application for a wasted costs order include where there are complex issues which are unsuitable for summary determination. A wasted costs order application is a summary procedure. If there has to be extensive disclosure or extensive cross-examination, the court should generally decline to make the order. There has to be causation established. If the costs which have been incurred cannot be directly attributed to the unreasonable, improper or negligent conduct, then the wasted costs order cannot be made. The standard of negligence has to be made out. It cannot be said that because a firm of solicitors is a specialist in a particular area, that they should be held to a higher standard. Where a solicitor has acted on counsel's advice, this can often be a complete defence to a wasted costs order, although it's important to bear in mind that a solicitor cannot blindly follow counsel's advice, particularly if that advice is evidently inappropriate. The more specialist the area of law, the more reasonable it's likely to be for the solicitor to put faith in what counsel has told them to do. Where there are issues of privilege involved and the client is not willing to waive privilege, and it's important to bear in mind that privilege is for the client and not the legal representative to waive, then the benefit of the doubt should be given to the legal representative and the court should decline to make the wasted costs order. And finally, proportionality has to be borne in mind. If the level of wasted costs is relatively insignificant, or the level of costs which have to be incurred in order to pursue the wasted costs application are substantial, then the court should decline to deal with the application. I hope that you found this training session useful. If you'd like to discuss anything which we've gone through in the video, then please do get in touch with me. It may be that you've got further training requirements in relation to costs, and if you do, again, please get in touch because we can provide bespoke training in any aspect of legal costs.